Good afternoon. It's good to see everyone. Today is Monday, October 20th, 2025. It's 1 p.m., and I'd like to call to order this meeting of the Tennessee State Board of Accountancy. Notice of the October committee meetings of the Tennessee State Board of Accountancy, including date, time, and location, has been properly noticed, and copies of the agenda were posted to the Board of Accountancy website on Tuesday, October 14th, 2025. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet, which is at the back of our room, or by placing their name in the chat box online. The public comment period will take place at the end of the meeting. Today's meeting consists of three of the board's four committees and their various agenda items. The full board meeting will take place tomorrow, October 21st, beginning at 8:30 a.m. I think most folks in the room are aware that we are welcoming three new board members, and we're glad to have you. And in accordance or our custom has been, I'll get it out in a minute, for you to ask you to introduce yourselves. So maybe Amelia, do you mind to start off and introduce yourself?
Thank you, Mr. Chairman. Thank you, Mr. Chairman.
Yes, ma'am.
I'm Amelia Hart, and I am grateful and very honored to be a part of serving the great state of Tennessee. I bring over 20 years of experience in the academy with both private and public universities. I am a champion of this profession. I respect what it brings to the table, and I look forward to being a part of the conversation and also contributing to where we are, but more importantly, where we're going. So thank you.
Great. And it's been my honor to attend some of your CPE courses in Knoxville, so you always do a great job with that.
Thank you.
Thank you for that. And you're also with a very fine institution, by the way.
I am. I should have started with that. I am with the University of Tennessee in Knoxville, a member of the Department of Accounting and Information Management, so it is an honor and a privilege to be a part of that institution and infrastructure.
Good. Thank you. Thanks for being with us. Daniel, do you mind to introduce yourself?
I'm Daniel Moore. I work with Watkins Uberall in Memphis. I've been there for about 25 years, and I'm an audit partner there. So I'm really honored to be on the board, so thank you for having me.
We're glad to have you. As I mentioned to you earlier, one of my really good friends, close friends, when I was with TSCPA I served on the board of TSCPA in various leadership roles, but Michael Uberall was always there supporting me, and I have fond memories of the times that Michael and I got to spend together. So tell him hello, please, next time you see him.
Will do.
Michael, glad to have you on board with us. And do you mind to introduce yourself?
I'd be happy to. Thank you. I'm actually from Middle Tennessee. People ask me if I've lived here all my life. I say not yet. But it's an honor for me to be representing Middle Tennessee here on the the Tennessee State Board of Accountancy. My career was a lot of places. I started at Price Waterhouse. I worked at Genesco, which is an SEC company. And then I spent the last 27 years of my career at the National Association of State Boards of Accountancy, where I get to spend time with state boards just like the Tennessee board. So it's such an honor to be here to see it from the side that protects the public. And thank you so much.
Thank you. We're very glad to have each of you, and thank you for agreeing to serve the board. So, I don't know that we have other visitors with us today. I typically welcome those folks, but I don't see any, so we will just move along. For the benefit of our new members, our new board members, today is the day that our committees meet, and as you can see, we're all in the room, and so we're all participating in some of the committee discussion, but the votes that the committees will do, only the members of that particular committee vote for those proposals. So we will get into that more in just a minute. And then I would also encourage you to remember to turn your microphones on when speaking and off when finished. only 4 of the mics are operational at any given time. So, and I'm typically the worst offender. So, but try to remember to turn your mics on and off. Okay, we will move into our licensing committee. Chairman Sam Bennett.
Thank you, Mr. Chairman. We've got 4 licensing matters that we'll be discussing today. The first relates to credit extension requests, and I'll turn it over to the Executive Director, who will walk through the details of each.
Thank you. So in your materials, you will see 2 requests for exam credit extensions to be heard, and then I have printed a third that we received late last week, and you should have that at your seat. So I will take us through all 3 requests, and then I will turn it back over to Chairman Bennett to lead discussion. All right, request number 1, and a reminder, starting last board meeting last quarter, we made these anonymous just because of the nature of some of the things that are behind the request. So request number 1, a Tennessee CPA candidate has requested that the board consider a 6-month extension of his reg score from an expiration date of September 16th, 2025 to March 16th, 2026, due to hardships his family has experienced in caring for their newborn daughter with medical issues. The candidate did provide health insurance information documenting several successive medical appointments for his child in recent months. So he was able to provide support for that. Notably, the candidate has also passed BEC, for which credit will expire on June 26, 2026. The sections he has left to take are FAR and audit. And I included a copy of his candidate score summary in the materials. Request number 2, a Tennessee CPA candidate has requested that the board consider an extension of his audit and BEC scores from an expiration date of August 30th, 2025 and October 10th, 2025, respectively, to November 30th, 2025 for both sections. The board voted to approve an extension previously of his audit score from June 30th, 2025 to August 30th, 2025 at the July 29th, 2025 meeting of the board. So the candidate had originally contacted the board in May of 2025 requesting a 2-month extension of his audit score from an expiration date of June 30th to August 30th, 2025. Subsequent to the initial request and just before the July board meeting, the candidate updated his request to extend his score to September 30th. The updated request didn't make it into the board meeting materials for consideration due to the timing of the receipt of the updated request. The candidate noted that over the past several months prior to his request, he had been traveling to Pakistan to provide care and support for his mother, who had recently suffered a serious spinal injury. The request for an extension to August 30th was voted on and passed by the board at the July 29th meeting of the board of this year. The candidate reached out again in October to us requesting an additional extension of his audit and BEC scores this time from an expiration date of August 30th, 2025 and October 10th, 2025 respectively to November 30th of 2025. The candidate provided the attached letter, which is included in your materials, noting that he had been traveling to care for his mother again in August of 2025. So he's already passed FAR, for which credit will expire in 2028, and the only section he has not yet passed is reg. So I think in this case, essentially, we're restoring the audit. The request has been to restore the expired audit score that was passed in December of 2021, and then extend BEC just a few months from its expiration date. All right, I guess I can pause there too, if there are any questions on 1 or 2 before we move into discussion. Any questions on the facts? Okay. Lastly, request number 3, which is printed in front of you. A Tennessee CPA candidate reached out last week requesting that the board consider an extension of his reg score from an expiration date of September 16th, 2025 to April 30th, 2026. His wife has recently experienced health issues that have required extra time and support from the candidate, and this has impacted his ability to pass all parts of the exam timely. The candidate did provide support from various medical patient portals that supported various procedures and appointments for his wife during the time from 2022 to 2025. He has also passed audit and FAR, for which credit will expire on 11/28/26 and 2/6/28 respectively. And his last remaining section to pass is one of the discipline sections for which testing windows are currently only offered in the first month of each quarter. So he has requested an extension through the end of the April testing window, which is April 30th, 2026. And that concludes the requests.
Thanks, Jen. So in summary, we've got 3 separate requests. The first is to extend for 6 months. The second, inclusive of the first request and the second request that piggybacks, gives a total extension period of 5 months. And the third request is asking for a 7.5-month extension, each of which, from my perspective, appear to align with a reasonable period based on the hardships or other circumstances that are outside of the candidate's control, which conforms to our historical practice, and I think also are clearly within the bounds of the board rule that allows us to provide a extension for candidates who experience hardship or circumstances beyond their control. So with that, I'll open the floor to any further discussion.
I agree that all of these fall within the realm of those situations that are permissible and certainly should be considered favorably.
Hearing no further discussion, do I have a motion to approve the extension requests?
So move.
Is there a second? Second. Any discussion? Do we need to do a? Okay, all in favor, please say aye. Aye. Okay, with that, we can move to the second licensing matter, which is a new exam that's been requested for CPE credit. Jen will walk through the details of that as well.
Yes, so we had a licensee reach out in the last quarter requesting that the board consider allowing CPE credit for the National Association of Corporate Directors exam. So this exam is a 4-hour exam. It is comprised of 50 multiple choice questions and 16 case studies. If approved, it would translate to 20 CPE hours. The rule is that an approved exam is granted 5 times in hours, 5 times the length of the exam. That's how we got to 20. The proposed field of study is specialized knowledge due to the content and weight of topics in the exam, which are listed in your materials. The exam is administered by Pearson VUE, which is a global computer-based testing administrator. So with that, I will turn it back to you for discussion.
So as was included in our pre-read materials, you'll see that the board has approved 38 other similar exams, which are currently eligible for CPE credit in Tennessee. From my perspective, the subject matter of the NACD exam appears both relevant and appropriate to qualify as CPE credit. And so the request appears reasonable to me, but I'll open it to the floor for committee members to comment. Hearing none, do I have a motion?
I make a motion that we accept this as CPE credit.
Is there a second? Second. Any further discussion? If not, all in favor, please say aye. Aye. Okay, with that, we will move to the third licensing item, which relates to a request for CPE from a non-registered sponsor.
Yes, thank you. I'll take us through the details of this. So as part of our annual audit of CPE compliance, one Tennessee licensee, license number 28214, was selected for an audit of his credits, of his 2023-2024 credits. His audit response included certificates representing 25 credit hours from the sponsor, Mark J. Kohler. Upon investigation by board staff, we realized Mark J. Kohler is not a NASBA-approved CPE provider. Considering the volume of hours that were submitted and the volume of penalty hours, which would be 16 additional penalty hours that would be assessed if we could not accept these CPE credits, we decided to bring it to the board to see if the board would consider approving acceptance of these CPE credits for this individual. We have listed the applicable board rules in your materials. I think I'll point out the third board rule there, Board Rule 0020-05-.0410. The board specifically reserves the right to approve or disapprove credit for all continuing education claimed under this rule. And a little bit of background on these credits. Mark J. Kohler, as a continuing education provider, is approved by the IRS as an education provider for enrolled agents, but is not registered with NASBA, which is required for CPEs for CPAs in Tennessee. There appears to have been some confusion regarding approval by the IRS versus approval by the board, and the licensee believed in good faith the credits to be acceptable. If these credits are not found to be acceptable by the board, the licensee would be required to make up the missed credits from the 2023-2024 reporting period, and 16 CPE penalty hours would be required to be completed for 2 CPE benchmarks that were missed as a result. So the question for the board today is to review and consider approval of the 25 CPE credits earned through the courses noted in the attached CPE certificates in your in your materials, specifically in the field of study tax.
Thanks, Jen. So from my perspective, the CPA invested the required amount of time that was necessary to satisfy CPE requirements, however, failed to realize that the sponsor was not registered with the NASBA. I guess I didn't realize the distinction that there were CEs that were marketed by the IRS that were not qualifying under NASBA due to, the not being registered as a sponsor of CPE. Given that the sponsor is registered with the IRS and the subject matter is relevant to the field in which the CPA primarily practices, it seems like a reasonable request. From what I understand, it appears to be an honest mistake where the CPA complied with the substance of the CPE requirement, but made an administrative mistake in terms of selecting CPE that wasn't registered or qualifying. So with that, I'll open it to any discussion from the committee members or other board members.
Jen, in investigating this, do we have a sense if Mr. Kohler's organization or Mr. Kohler himself were to go through the NASBA process? Is there much by way of difference in terms of does IRS more or less rigorous than NASBA would be in terms of awarding someone to be a eligible CP provider?
I'm honestly not very familiar with the IRS's requirements for approving a CPE provider. I know that NASBA does have rigorous standards that are required to be followed by any provider that wants to be able to provide CPE to CPAs. So I can't speak on the IRS. I don't know that I can accurately answer that question on the IRS side.
I can say,
Oops.
go ahead.
I do want to say there was one thing that did concern me. 25 is pretty substantial, but it does say clearly on the certificates that if applicable, CPAs, attorneys, and others licensed by state boards should check with their respective boards. That concerns me that there was such a significant number of CPE that was earned, and there's a clear disclaimer that puts the onus on the CPA to verify acceptance. That is a concern for me. So even though IRS may endorse it, there are certain standard setters where we can't just apply and take a one-fits-all approach. So that does concern me.
I have a question. If we did perhaps approve this, is that essentially approving anyone getting credit with Kohler? Or just this person?
This request is specific to this instance, this person and these CPEs. So it's not, at least as it has been presented, it's not a request to consider this vendor as a board-approved vendor outside of the NASBA sponsors.
I guess my concern would be, would we set a precedent with others who have taken his courses, and then would see that we've granted it to him, and then they would expect to be granted credit as well. Just a thought.
I think that's something to be considered.
Yeah, I think that's it's a valid consideration. I think another consideration is, would the punishment fit the crime? So if we do not approve it, he would be required to go back and take 25 additional hours of CPE plus a 16-hour penalty, so 41 hours of additional CPE. So I think that's, another key item to consider.
So would we have the option to waive the penalty if we wanted to?
Yes.
If we were to deny the request, how long does he have to remediate?
So in rule, the board can grant up to 180 days to complete any penalty hours. In practice, when we are assessing penalties as part of the CPE audit, we give licensees 30 days to complete penalty hours if they are 8 or less hours assessed, and if it's greater than 8 hours, we give 90 days typically.
From today, presumably?
Yes,
Or until, from tomorrow, whichever?
from when notified, yes.
Whenever notified, okay.
So one option would be not to approve the 25 credit hours and almost provide a no harm, no foul as long as you make them up in the next 6 months.
Yes, that could be an option.
Is it 6 months or 90 days? Did you say?
We typically give 90 days from that, and that's just board staff practice in carrying out the CPE audits. If a licensee is assessed, what did I say, more than 8 penalty hours, we give them a window of 90 days. And of course, if there are extenuating circumstances, we take those into consideration too. But generally speaking, that's the time window. But we have up to 180 days in rule.
May I make a comment, please? I'm not on your committee, but I'm looking at this, if I may. I'm looking at the certificate that he attached to his memo, Ryan Page here. And respect to Dr. Hart, I agree with you. It does have a disclaimer that says, check with your NASBA or whomever, your state board. But there's other language right around it that I could see how you could be very confused by it. There's an IRS stamp on there that says CE approved. Then there's another that says, this is based, you get 10.6 credit hours based on a 50-minute hour. That's our language, 50-minute hours. I could see how the guy might be a little confused by this. I guarantee you after today, he will not be confused about it again if we were to approve it. That's just my comment, so.
Yeah. I think when it says specifically with approve, especially with all of the conversation around CPE and this continuing ed for most professional organizations, that's a deep sigh for me on that. That's just a deep sigh.
Well, you're the professional on that for sure.
Any further comments?
Sam, I'm sorry, I just was going to suggest or maybe it's more of a question. If the motion is denied, but it sounds like there's some potential appetite for some level of accommodation, do you do a motion to approve, and then if that does not pass, then you do a motion to come up with an alternative?
I think you can make a motion. I'm going to defer to, I think you can craft a motion how you would like it. Like, this is not a motion. This documents the
Any of the
request.
committee members can make a motion.
Right.
If it gets seconded, then there's discussion, and then a vote would ensue. If that motion does not pass, then we would take another motion.
And Karen gave me a good reminder. The motion that the committee brings is will be a recommendation to the full board tomorrow, so there could be continued discussion on this.
Yeah, we're just forming our recommendation through these discussions.
Okay, fair enough.
But that's part of the reason that the board members are encouraged to participate in the discussion to eliminate a ton of discussion tomorrow. Can't vote today, but you can
Yeah.
participate in discussion.
Yeah, so really, there's three options. So there's approval of the request, there's declining the request, which would result in making up 25 hours of CPE, 16 penalty hours of CPE, or there's a third option where we would decline the request, but potentially waive the penalty hours, but require the 25 hours to be made up over a 90 to 180-day period.
I'm sympathetic to this gentleman. I think it's a very dangerous precedent to start opening up credits to another provider that's not in the CPE registry. So, Sam, I like your third option. Don't feel like punitive action is required, but I do think it's a risk to start accepting these kind of credits.
Mr. Chair, I would like to add that if we do go the route of the third option, which I think is the best option, that we actually state that since it is a governmental entity and that they provided the CPE, that, that we're doing this option as far as giving him more time and not penalizing him for the rest of it, so that it could be a kind reminder in our ethics program that, you really have to make sure these people that you're claiming credit on are on the CPE registry. I mean, because we need that rigor. We need to know that they're doing it right. It came about because of the fact that we were having people just going through and getting education that was not performed correctly. And so we need those rails to make sure that we have quality products out there. And so I would suggest that be included in the recommendation if possible.
I would also be in favor probably of the third option. And then if Kohler wants to, he can always register with NASBA and get approved but.
I agree. Third option, to open up the doors to endorsing this does set a precedent, even if we did not want to or intend to. It also opens the opportunity, if it were me and I needed hours, I know there's a difference, but I needed the hours, I would submit and ask for those to be considered as well. So selectively saying yes to one and no to the other, I don't think is something that is wise. So option 3 as well.
I'd also like to point out that if a speaker from the IRS goes to a qualified organization such as the Tennessee Society of CPAs or a chapter of the one of the chapters for the Tennessee Society, that any of that is done and they've given credit for who attend based on the Tennessee Society of CPAs CPE number. And so this just seems to be a one out where somebody just, the IRS came together didn't have a sponsoring organization. And I've had a lot of speakers from the IRS that I've gone to that I went through, I didn't pay for it. It was part of my chapter where they came and just did it for those attending, or I did it through a school who had one of the speakers, and I got credit for it, because they were the ones issuing it. And so I would highly encourage people who are doing this to do it with a sponsor if they don't have their own sponsorship number, which is easy to get. It's not that expensive. We used to do it in our firm at Burke. And so it's not a big deal. But you do have to check the box and make sure that you do everything correctly and that you send out things correctly. And so, but just as a side note.
Yeah, and I think I might offer some clarification too. The provider, Mark J. Kohler, appears to be, I should say, registered with the IRS. So I believe the IRS has a separate continuing education registry process similar to NASBA's. So this individual appears to be registered as a provider with the IRS. So it's not necessarily the IRS coming in and offering a presentation, if that makes sense. It's a separate, distinct provider who is, instead of being registered with NASBA, he's registered with the IRS as a continuing education for enrolled agents.
I didn't know that, but in that case, maybe we need to send him a letter and say that his education does not qualify for Tennessee credit, and make him aware of it too.
Yes.
So maybe he has a advertising problem.
Yeah, I like option 3 as well. I am sympathetic to the time frame and the 25 hours being more than inconsequential, so I would suggest that if we make a motion along those lines, and considering that we're about to go into year-end, busy time for CPAs, that we do extend the period to be a little bit longer than 90 days. I would encourage up to the 180 if others agree. Does someone want to make a motion, and we'll go ahead and see if we can get a second and a vote?
I can make a motion, or a recommendation, I guess it is technically. So the recommendation being that Mr. Page's request for an exemption is not, is denied. However, we do recommend that the credit hours, the 16 credit hours that would be required as a penalty be waived in this case, and that he be given up to 6 months to complete the 25 hours that he is deficient. And let the record note as well that we are not setting a precedent, and part of the reason the recommendation is because of what we do perceive to be an inadvertent error, as opposed to simply a decision to willfully not take CPE.
Is there a second?
Second.
All in favor, please say aye.
Aye.
Okay, with that, we will move on to licensing matter number 4, which involves an approval request from a foreign education evaluation service provider.
Okay, I'll take us through the facts. In the last quarter, a representative from Scalaro requested that the board consider Scalaro for approval to be a foreign education evaluator for Tennessee CPA licensed candidates who completed education outside the United States. So as a reminder, Board Rule 0020-02-.016 and 6A state the following: a graduate of a 4-year degree granting institution which was not accredited at the time the applicant's degree was received or at the time of filing the application will be recognized by the board as a graduate of a 4-year accredited college or university, provided a credential evaluation service approved by the board certifies that the applicant's degree is equivalent to a degree from an accredited educational institution. Scalaro is a member of the Association of International Credential Evaluators, AICE. AICE is a professional membership association for those involved in international credential evaluation and comparative education research. Board staff reviewed sample reports provided by Scalaro, noting them to include the appropriate information needed to process an initial license in Tennessee. Board staff also reached out to NASBA for further context regarding this evaluator. NASBA noted that they have not had significant experience with this provider. Further, NASBA noted that Scalaro is not a member of NACES, so there are not many jurisdictions that will accept their education evaluations. AICE and NACES are both organizations that offer membership to foreign credential evaluators. Both organizations maintain standards that are required to be followed by their member organizations. Notably, our board currently has 8 approved foreign credential evaluation services, which were provided in your materials. 7 of those 8 approved organizations are members of NACES, and 1 is a member of AICE. So the request before the board today is to review and consider Scalaro for approval as a foreign credential evaluator for Tennessee CPA licensed candidates.
Thanks, Jen. So, as Jen just mentioned, we have already accepted another foreign credential evaluator who only has a membership with AICE. So 1 out of the 8. And another point that I think is important to consider is that we can't fully mitigate the risk associated with the foreign credential evaluators, just given that there is the opportunity for a candidate to become licensed in another state and then transfer their license to the state of Tennessee, through a foreign credential evaluator that we might not have approved. So it's not a risk that we can fully mitigate, and it seems that we've already set a precedent that membership in AICE is acceptable, given that there's another provider that only has that membership who has previously been approved. So with that, I'll open it to the floor for any further comment.
I have a question on this, Jen. Have we ever, historically, that you can recall, or anyone on the board, withdrawn such authority that has been given to one of these organizations before?
I'm so glad you asked, because this board has done that in the past. We were alerted to, this predates me, Karen might remember more details than I do, but we were alerted to, in normal review of applications, we were alerted to a credential evaluator who had been assessing as equivalent, I think maybe it was like 90-hour degrees from universities abroad, from one or two specific countries that they were translating as the equivalent to 120-hour degrees in the United States. And once that came to our attention and became kind of a conversation amongst multiple jurisdictions, it was brought before the board, and the board voted to no longer allow that provider as an approved provider. So they're no longer on our list.
So accepting this, there's no red flag based on the review, is what I'm hearing, based on the staff's due diligence.
Not that I can see.
Jen, did you take a look at this individual's transcripts, separate and apart from what the credentialing service did?
Do you mean when we license individuals who have education from outside the United States?
Or, yeah, either now or I guess ultimately.
Well, this is a request from the organization, not a
Right.
request
Oh,
from a
I'm sorry.
candidate.
Okay.
Yeah, that's right. Yes, this is a request from an organization that provides this service to be approved for use by Tennessee candidates. But we do look at, when we get a package from NASBA from someone who is ready to be considered for licensure, all of those transcripts, including the report from the evaluator, are included in that package.
Okay, no, there's no further discussion. Is there a motion to approve this provider?
So moved.
Is there a second?
I'll second.
All in favor, please say aye. Aye. Okay. So that concludes the licensing committee prepared remarks and the matters that we plan to cover today.
Thank you, Mr. Chairman. One of the agenda items was related to CPE, which we discussed, the CPE request. Jen and I participated in a Southeast Region call for NASBA, the NASBA Southeast group, consisting of executive directors and board chairs. And I think that was in August, Jen, as I recall, sometime after our last board meeting and before this one. But one of the topics discussed was the number of CPE hours that an individual may earn in a 24-hour period. And of course, we had no authority to take any action on that, but Jen has experience on this, and sometimes we've seen situations where people claim more than 24 hours on a given day, particularly toward year end. So, yeah. Maybe they have two computers running at the same time and are answering the questions. I don't know how you do that, but maybe Brad would have insight on that. But it happens, and it's not just in Tennessee. It happens at least across the Southeast, probably nationwide. But
They do it in the air. They leave Singapore in the morning and fly to London and fly back to Singapore, so you know they get the whole day, more than 24 hours.
Right. So, just for your information. Okay, we will move to our Enforcement Committee and turn it over to Chairman Andy Bonner. I will tell you just, that's my watch, and I'm sorry I didn't silence it. I silenced my phone, but not my watch. There's a tremendous amount of work that's done on these enforcement cases by our staff, by our executive director, by Karen, by our investigator, by our attorneys, Lee, Kyle, Laura. And so a lot of work is done to get to this point. And then some of these cases are very fact intensive. And so this report might take a little bit of time, but Mr. Bonner, I will turn it over to you.
Thank you, Mr. Chairman. We're going to go first through the case and complaint report. If you'll pull that up in the early handouts, you'll see a list of our case and complaints report that are outstanding. We actually have 24 on that list. You've got 24 CPAs on that list, and then 4 firms, so for a total of 28. If you go through and look at it, you can see that some are in litigation monitoring, as most of y'all know, and that's a situation where we set the case aside and we say, let's monitor this and wait until legislation is finished on any of them, and then bring it back before the board. We have some that have not paid. They're on payment plans, or they've never paid any of them, and so we have collection notices go out against them. And then we have some that are in a legal investigation, and you can tell by the number of days which ones are which, or that the staff is, the response is requested. And so you can kind of go through that and look at where it is. RB is a regulatory board complaint. And then you can see the attorney or the person who's following up on it. And so we usually present that before our enforcement discussion in committee so that each person can see where we are and what our backload is. And that kind of came about several years ago because we had a huge backlog where we had some staff changeover, and we wanted to see just how far behind we were as a board. And so for the new members, that's the reason it's reported. And I would say if you have any questions, we can ask those now. All right, seeing none, we'll go over to our legal report. And the legal report, we're going to start with something new today. I know that before this board, the request was that we can actually assess cost of investigations, and I might say here that the cost can include, but are not limited to, the incurred and assessed for the time, the prosecuting attorneys, investigators, expert witnesses, administrative judge, and any other persons involved in investigation, prosecution, and hearing of the action. And so our attorney Lott, Mr. Lee Lott, he has put together like a memorandum that I requested to bring before this committee to vote to assess it and to discuss how those costs will be assessed and kind of run through it and then present that tomorrow to the board for approval of that process. And so today you will see that there are some costs that are recommended for cost incurred and or a cost with an action. And so, Mr. Lee, walk us through, and I think you have a handout, don't you, to give to the board members so that we can kind of read through it?
Yes, sir, I can. This is a memo to you, but I printed off a few copies, extra copies in case anybody wants to see it. But all it is a statement of the controlling law, the statute that provides regulatory boards authority to assess costs, of course, applies to this board, and it's very clear. And I guess I will ask Karen, as you'll see from this statute, and I know you've looked at it before, we've discussed it before, except for the new members, of course. But the key sentence right at the start, the board may assess the actual and reasonable costs of the investigation, prosecution, and hearing of any disciplinary action that's held under the Uniform Administrative Procedures Act. So basically all of the cases. In the past, the board has not added costs at the consent agreement stage. That's because we were trying to present the case to the respondent and settle it. If the respondent didn't settle, the board would hold a hearing over that case, and costs would be typically requested at the hearing. What we're doing differently today is a response to discussion the board has had. The board has actively discussed adding costs for, I've been working for the board for a little over a year, and probably at least 3 meetings. It's been a key topic that the board has had strong interest in assessing costs, and a part of the motivation there is to make sure that the bad actors pay the cost instead of passing that cost on to the profession as a whole. So it's got to, but you're limited. The board is limited in its ability to do that. So what we're doing here is a kind of in a modest way, is to introduce costs as an element of our recommendation. So you've been presented with a legal report. That is essentially Mr. Johnson and my recommendation to the board on how to handle each of the disciplinary cases that's come up and that's ready for your deliberation and decision. And we, for the first time now, have included costs. I will say this is a bigger issue. The other programs are looking at this as well. Some have already been doing it, some haven't done it, in terms of adding costs at the settlement stage. So the recommendation is for these disciplinary cases, it's in the legal report that you have in front of you. Now, of course, as with all elements of the legal report, it's only a recommendation. The board anyone can make a motion to handle the particular case as you wish, and the board can deliberate and decide that question. So, but just know the purpose of the memo that we handed out is to keep us aware and mindful of the limitations under the statute in the Tennessee Code. It must be an actual cost. It must be assessed in a reasonable amount. And it can only be for activity that occurred with the investigation, which would be Mr. Speed, the prosecution, which I guess you could generalize and say that's when the case is prosecuted by Kyle and myself, and then the hearing, the conducting of the hearing. And then at the hearing, of course, there might be court reporter costs in addition to time. So, Mr. Bonner, that's a run-through of it. Is there any question that I can answer for you?
Yes, sir. First of all, I know today we're presenting 12 consent orders or consents for our regulatory or our legal report. How would that affect those consents? As far as is Mr. Speed's time not in that? In other words, is there a pool of time that we're kicking out because we didn't find anything that was lack of, for example, lack of jurisdiction or, that we lacked evidence or anything like that.
Right, we're not going to recommend assessing costs to a respondent in a case where we're also recommending closure. Again, that's a recommendation. The board may see it differently. It's up for deliberation and questioning, but no, that's right.
And so, and the reason I'm asking that is because now we go to our next phase, which is we're at 10 today under proposed discipline. So if we're keeping track of our time or our expenses related to that, so that it's just that time that's related to those proposed discipline cases that we're saying that we have this allotted time and we're coming up with a total bucket of that time, or is that time really documented exactly for what case or the specific case that he worked on?
Well, the way we've handled recording time in the past has been to, for example, with an attorney, to start keeping track when we file a notice of hearing and charges. In other words, if settlement fails and we have to draft a notice of hearing and charges, which is like a complaint, and that's not the right word, it's just a way to commence a formal proceeding under the Administrative Procedures Act. And it's essentially a request to the ALJ out there, so to the Administrative Procedures Division to assign an ALJ and have a hearing. And we even have discovery prior to the hearing. So once that commences, the attorneys start keeping time. But we're at a early stage here. We're not at the, I use the phrase NOHC, Notice of Hearing and Charges. What we're doing today is before all of that. This is only your decision on how to handle the case, and then your decision on whether formal proceedings can be filed and whether we can approach a respondent about settlement. And so we have the only cost element that we're including and able to include here with this recommendation is for investigator time. And so that's what you see in the recommendation.
And that's principally what we're adding new to this, is just investigator time associated with this.
Yes, sir.
May I ask also along those lines? So that would be, the half the cost would be if they settle, if they agreed to settle, correct?
Right.
And if it goes past that, then we've got a whole nother set of
Right,
costs.
so we start over.
Because then y'all get more involved, right?
Right, it's a
Okay.
new ballgame. It's like if a respondent declines to settle on the terms that you authorize today and tomorrow, then we would have further authority from you to file a formal proceeding. And at the proceeding, at the hearing, the board and the ALJ preside and decide how to handle it. And so the question of cost would come up as a new question.
How many hearings do you really have, like in a quarter?
I haven't had one since I started a year ago, but, I know that they occur. They're not, I wouldn't call them rare.
Well, one thing that was kind of asking that, so if we have the investigation cost, we would bring it forward to now the hearing and add it to it, since the investigation cost can be added to the entire process. So we wouldn't start from scratch, but we would actually bring that initial investigation cost forward and then keep going.
Correct.
Okay, all right. So the whole purpose of this is to make sure everybody's on the same page. It's my understanding, and I'll let Mr. Lott address this right now, that the reason we didn't have this before now was that we wanted to make sure that we were consistent with all the other regulatory boards in Tennessee in how we applied this code. Is that correct?
Well, why it originally hasn't, I don't know, in years past, it might have been included. Again, my scope is pretty much limited to my tenure, so that's not very long. But that is a key consideration, yes. I mean, the board, the programs, this is an important issue to all other programs. So it has, and the leadership wants to make sure it's done in a consistent and fair way, and of course, first and foremost, under the statute.
Thank you, Mr. Lott.
Mr.
Great job.
Chairman, sorry. Many of you have heard this from me before, but the new members have not. we work closely, I feel like we work very closely with the Department of Commerce and Insurance and Assistant Commissioner Reed Witcher. And Reed and I have had discussions about this. I think I can't vote for Reed, of course, but I think that he generally is supportive of us being able to add costs as appropriate, because we're spending a lot of time and cost investigating some cases. And so I would personally not want us to do something that is in conflict or something that the Department of Commerce and Insurance does not want us to do, but I think we've got the green light to proceed with this.
I'm just curious, are these costs incremental costs, or are they costs that were going to be incurred anyway? Does each case drive higher cost?
Each case is different, and some require a lot of work. Some respondents are not particularly responsive. So, yeah, each one is different.
Any other questions related to it? So today, you're going to see on the cases, on the legal report, that those costs are included. And the cost may not be specific to a case under a proposed discipline, but it may be in a bucket of, in other words, reasonable was used a lot in what you said, Mr. Lott. So in some cases, we just, we put an hour of worth of time in there, or we know what our investigation costs were for the period, but we didn't assess all of that investigation cost.
That's right.
So in other words, it's being applied in a reasonable basis for the benefit of the licensed CPA in the state. But there is a cost that sometimes runs over where it doesn't become reasonable, that it takes more time to do something because of people not responding or not getting things in, and then we have to go back and redo the case and look at it harder or deeper and ask for some additional information or follow up to get the information we were promised. And so it's my understanding that we are very much considering that reasonable phase in this to make sure that we apply it appropriately.
Absolutely.
So we're going to jump in to the legal report. Now, with that said, just to shake everything up today, since we're already doing something different, we're going to try something different today, being the fact that I was honored to be on NASBA as a regional director, and I got to see how other states did it. I never really challenged our methodology of having somebody sit and read the reports, but we have staff and attorneys and investigators sitting over here that are very knowledgeable of each one of these cases, and they can answer the questions better, and they can summarize them better. And so normally the attorneys at most of these other boards actually gave the different reports with the, with what they recommend on the case. I think that we're probably different in the fact that we put all our consent, together, and then we put our proposed disciplines together, and sometimes we wrote on all the consent ones for closure at the same time. And so we're going to continue that methodology today and see how that goes. We have two attorneys. We have Mr. Johnson and we have Mr. Lott that actually did the different ones, and you can see their initials on the cases. And so when we get to that, then we might be popping back and forth to the attorneys, the different attorney in that case. For the new board members today, what we do is when we take a look at the consents and foreclosure, we vote on them all at once. However, if somebody is not comfortable with that and we want to discuss it, and then we see that there is a lot of discussion about it, we will pull that case out and vote on that case separately. The same on the proposed disciplines. Sometimes we don't have any disagreements on the proposed discipline, and we'll vote on all those at one time. And then if we have a lot of comments or items that don't seem right, then we'll pull that one case out and we'll have more conversation on it. And then our re-representations, these are cases, as we kind of talked about, that have been in litigation monitoring, and that's what the majority of them are. We have 2 today. We put down the facts of the case. We put down what the update is, and then we talk about the proposed discipline associated with it. So with that case, or I guess it's a bad term, with that report, well, I'm going to let Mr. Lee walk us through, Mr. Lott, pardon me, walk us through and go through our consent.
Yeah, I'm going to defer to Mr. Johnson for the first view, since he's got the first view on the report.
Okay.
And I've only got 4, so I'll go ahead. And for those new members that I didn't get to meet, my name's Kyle Johnson. I'm one of the disciplinary attorneys for the board here. So I'll direct you to item number 1 on the consent agenda. And as Mr. Bonner pointed out, all of these on the consent agenda, the recommendations are to close, where generally no violations were found during the investigation. So we'll start out with number 1. That's case number 2025-034-881. I'll just give a brief summary. These were some allegations related to some tax services the respondent was providing, some lack of communications, and allegations that the respondent was behind on the taxes. Ultimately, the respondent did provide an affidavit to the effect that most of that was due to the complainant's fault of not providing some sufficient information in order to get those timely filed. The investigation did not reveal any evidence of any violations of any rules of professional conduct in this case. So the recommendation is to close on that matter. Are there any questions on item number 1 there?
Why don't we just go through them all, and then we'll stop at the end on these, on the consent.
questions.
Yeah, for questions. And so just mark down any of them that you have questions on as we go through it, and then at the end because usually the ones for closure, there's not much discussion about.
Sounds good. All right, we'll move on to number 2 there. This is case number 2025-037-931. The allegations here were related to some unethical conduct. The complainant alleged that the respondent had committed unethical conduct by attempting to help the complainant's ex-husband refinance the marital home. Ultimately, the complainant had no evidence to support her allegations, and it was merely a speculation. The recommendation here is to close. Number 3, item number 3, case number 2025-046-061. These were also some allegations related to tax services. It appeared to be over just one form where there technically was some kind of technical finding that something was wrong on that form. Ultimately, both parties cooperated with the investigation. The respondent did acknowledge that one mistake, but confirmed that there was no liability on the complainant, and the complainant also confirmed that. So based on that, our recommendations is there's no pursuable violations, and the recommendation is to close. I'll direct you all the way to number 11. That's my last and final case on the consent agenda. That is number 11, case number 2025-045-851. This was a referral from the Board of Licensing Contractors related to a review report that the respondent did submit for a contractor applicant. Ultimately, the respondent here is licensed out of state, and the contractor applicant company is also licensed out of state. So all the preparation and the transfer of this report was not performed in our jurisdiction, so the respondent was not practicing in Tennessee, and we ultimately don't have jurisdiction to issue any violations. And so my recommendation is to close and refer that matter to the appropriate state board, because it did appear that she could be in violation of some of the rules in the appropriate out-of-state jurisdiction. And those are all my cases. I'll forward it over to Lee.
Okay, so the consent agenda is cases 1 through 12, and Kyle just went over 4 of them, and then here are the 8 remaining ones, and it's cases on your report, cases 4 through 10, and then number 12. So number 4, here a complainant alleged that respondent, who is a Tennessee licensed CPA, failed to complete tax preparation services for the complainant and for the complainant's corporate entities. And the big issue here is that the IRS assessed a penalty for the failure to pay the proper estimated tax. A smaller amount was paid than was owed. So the key here, like a lot of these cases, is that there's no evidence. Complainant has not provided any evidence to show that the respondent directed the complainant to pay a lower amount than the estimated tax. That's the basis for dismissal here, and for a lot of them, lack of evidence. Number 5, respondent prepared complainant's federal and state income tax returns for the year 2021. And then after filing, the parties learned that North Carolina, which was the state portion, no longer taxed military retirement benefits. So respondent prepared an amended state return to resolve the issue and obtained a refund for the complainant. The respondent further waived fee for work on this. So these facts do not present a violation of the Tennessee Accountancy Act. So closure is the recommendation. Number 6. Here the board administratively filed a case. Respondent appears to use the designation CPA firm on its website. In response, the respondent states, "We removed CPA firm," I'm reading a quote from respondent, "We removed CPA firm word from my website, and we are moving from Tennessee State as well." So Mr. Speed investigated this and confirmed that the respondent is no longer advertising Tennessee-based services on its website, and respondent no longer maintains an office at its previously advertised location in Tennessee. So here it's a close for lack of jurisdiction. That's the recommendation. Number 7, complainant alleges multiple failures in a bookkeeping and tax preparation engagement. And respondent is an individual, not a firm, and he denies the allegation. And he further says he does not practice in Tennessee. There was a question because complainant filed did a search and found on a website that respondent showed a Knoxville address. But the investigator investigated this matter, actually traveled to Knoxville, looked at the location. There was, it was closed, no visible tenants. The investigator also confirmed that respondent does not list a Tennessee location on the firm website. The website does list offices in North Carolina and Florida. Notably, the title of the respondent's firm includes the word accounting. It appears this case is going to be of interest to North Carolina and Florida, and so the recommendation here is to close, but to refer it to those other 2 jurisdictions for consideration. Number 8, complainant alleges that the respondent CPA e-filed tax returns without the client's signature on Form 8879. Instead, the allegation is that the respondent CPA used a ghostwrite machine to get a signature on that authorization form. The respondent totally denies this and added, "I don't even do tax returns." So the investigator looked at this matter and interviewed some parties and determined that the complainant does not have firsthand knowledge of this allegation. Now, the complainant was terminated for cause. The respondent made a big deal about that, but of course that's not relevant. I mean, a person who's been terminated for cause may still be right about a complaint. So the key is that there's a lack of evidence. So the recommendation is closure. On number 9, complainant alleges that the respondent CPA failed to exercise due care in an engagement for tax preparation services. We see some of these. The complaint doesn't really specify which services are at issue, but there was a complaint, a response, and then the complainant submitted a rebuttal, and it clarified that the real issue had to do with the tax period in question, quarterly Form 941 for the second quarter of 2021. Complaint alleges complainant alleges that the respondent failed to pay the appropriate payroll tax that quarter. And the respondent denies this allegation. The investigator interviewed the parties and ultimately determined that there's no evidence that respondent even had the authority or access to pay payroll taxes. If the complaint is that the respondent failed to pay it, and there's no evidence that they even had access or the ability to pay, then there's not enough evidence to go forward on a formal case. We can't file a case based on limited evidence like that. So the recommendation is closure. Number 10, complainant alleges that respondent breached an agreement to provide certain tax-related services, which they describe as advanced tax strategies, including tax filing, LLC setup, and arranging equipment leasing, essentially a strategy to reduce a tax burden. Respondent is a CPA licensed in California, not here. That doesn't mean they're not subject to the jurisdiction of this board, but that's worth noting. So this dispute is already the subject of two other tribunals. First, it's the subject of a civil action in the United States, in a federal case in the Western District of Tennessee. Secondly, this dispute has already been the subject of an administrative case before the California Board, the Board of Accountancy in California. And there, the California Board issued a letter determination, and the quote is, "This disciplinary action is not warranted." I don't have the basis for that, but that is their decision. So the recommendation here, like the case in California, this case should be closed because the board lacks jurisdiction. Essentially, this is a civil action. It's a dispute that's best resolved in the civil courts, which is being resolved in right now. Is a little further write-up about how in the Tennessee Accountancy Act does have a general prohibition against fraudulent acts. I think it's quoted there, but there's not evidence of that. So this case is really a recommendation to close for two things: lack of evidence as well as lack of jurisdiction. So I'm jumping now to number 12. Number 12 has to do with a respondent that you're actually already aware of because the board held an emergency hearing a few weeks ago. A particular CPA was indicted for alleged criminal conduct, in specifically the allegation was theft from an employer. And the board had a quorum and voted to, that particular respondent voluntarily agreed to a summary suspension of his license. I'm not mentioning him by name, by the way, just because that's the course that the board prefers. I don't think there's a legal prohibition on naming the name, but just for the sake of being consistent with the way these things are handled, I'm not even going to mention the name, but the board is aware, and the board did vote to ratify the summary suspension. This particular CPA's license and firm permit have both been suspended pending the criminal case. So, and that's a state law, that's a state court criminal case pending in Jefferson County, Tennessee. Separately, just so happens that this particular respondent had two additional cases filed, not because of the criminal case, but because of basically unlicensed activity. I think I outlined it there. Performance of a test services in violation of board rules. So this particular respondent has a license, has a firm permit, but didn't have a peer review enrollment, and so was not authorized under the law to perform attest services. Now, both of those cases actually concern the very same attest project, the same attest service, the same report. So we don't typically keep two cases going if they're over the exact same thing. And so here, that's the case. So the recommendation is to close one of those duplicative matters. It should be closed as duplicative. But now, the first thing I talked about, the criminal matter, and the second thing, the one of the two attest cases, those, the recommendation is actually to place it in the litigation report. So it's not a discipline, it's not a recommendation of discipline, but it's to place it in I'm sorry, I used the wrong phrase, litigation monitoring, which what that means, it's going to be set aside and we're going to watch for an outcome later. And when the criminal case is resolved in Jefferson County, then we'll present this case back to the board and the board can make a final determination on how to handle this conduct. So, sorry that took a long time, but that's now the 12 cases in the consent agenda.
And I would say, we debated about, and we need board input here, just presenting the consent agenda and say, are there any questions? But out of our historical, on our history from this board, we've always gone through them to read and give a brief summary. And so we did tag that and keep that so that we could very quickly go through it. So now we have cases 1 through 12 on the consent agenda. Are there any questions related to any cases of 1 through 12?
Andy, actually, I do have a question. For number 6, Lee, it says, to begin, it says, in the case filed by the board. Is that this board? Or is that a different board?
This board. And what that means is that the board, sometimes board staff becomes aware of some matter that requires the attention of this board for possible discipline. And so we open up a case in the online portal, and
Okay.
then that starts the process.
Okay, okay, fine. And then this, if I just read this, it seems that the allegation was that this individual was doing work as a quote-unquote CPA firm. And then when we followed up, the individual said that they're leaving the state. And as such, there's lack of jurisdiction. But was that individual working or advertising, notwithstanding the fact they may have subsequently moved? What were they at the time that the complaint was lodged? Were they functioning as a CPA firm in the state of Tennessee?
You know, in a way, we're limited by the scope of the complaint. So the allegation here is that they're actively doing this. No particular customer or client stepped forward and said, hey, you know, they messed up my particular engagement. So the scope of that disciplinary matter is to look and see if they're doing what's alleged. And we determined that they're not, and they're not currently in the state. And so it could possibly be phrased as a lack of evidence. I'm not
Okay.
certain lack of jurisdiction is the only basis.
That's where I was going. It seems, you know, I wouldn't want someone to think, oh, well, I can just say I moved, and therefore we say we don't have jurisdiction, because I would think if it was dispositive that they were doing something at the time, even though they've left the state at some point subsequent to that, we would still have jurisdiction for the period of time in which they were operating in the state.
Right. If there was evidence here, we would present it to the board.
Okay. So that might be my only recommendation, is to maybe clarify that this maybe, to your point, is lack of evidence as opposed to lack of jurisdiction.
I think that's reasonable.
All right. Any other comments? So do I have a motion to accept cases 1 through 12, specifically with case 6 recommendation changed to lack of evidence?
So moved.
Do I have a second? All right. All those on the committee that are in favor, say aye.
Aye.
Opposed? Okay. Now we'll go on to our proposed discipline. We'll start here. There's 10 cases, and we'll start with case number 13.
I actually have the majority of the proposed discipline, so I'll knock those out. Go ahead to number 14 on proposed discipline. This is case number 2025-036-551. This was an internal complaint that was opened based on a CPE audit the board conducted, ultimately based on the complaint, the response, and the investigation, we did determine that there was a violation of failure to respond to board communications within 30 days. And also, during this investigation, the respondent did admit to performing an attest service without having peer review. So ultimately, the recommendation is to authorize formal charges for those violations. There's actually 3 violations, 2 failure to respond. One would be not responding to the initial board communications regarding the CPE audit, and then they also failed to respond to the complaint within 30 days that was opened. And then after investigation, that revealed that there was an additional violation of Okay. I apologize. This was a notification from being notified from peer review. So this was not a CPE audit. I mistakenly said that. But ultimately, it's 2 violations of failing to respond to one board of communication, failing to respond to a complaint, and then also, because of the lack of peer review, they did admit to performing an attest service without having that peer review. Ultimately, I'm recommending a consent order with a civil penalty of $2,500, consisting of those 3 violations, and also half of investigation costs incurred in this matter. And, Enforcement Chair, would you like to go do a vote on each one, or do it similar to the consent agenda for this?
On this one right here, let's just do a vote on each one.
Okay.
So that if there's any discussion, because we may have some discussion about them.
Sounds good.
All right, so case number 14 has been presented. Is there any discussion?
I would like to know from Duke, there's 6 of these under proposed discipline that have half the costs associated with, or assessed to them. Could you estimate, like, how many, once we get to each one that has one of those, tell us how many hours you spent on that? Is that possible?
I'd prefer, since any of these cases could then end up going to a formal hearing, so when you guys ask Duke a question, he'll probably relay that to me, and I can do it. Since these are public meetings, we wouldn't want anything he could say in here to be used in something else further down the road. But I can answer that question. So we do have, each case, we have the cost of his estimated time, and I can certainly pull that up and tell you. I think for each case, it probably ranged anywhere from $200 to, we had one that was closer to $1,000 in investigation costs incurred. But anytime I'm recommending half of investigation cost, that is specifically what was incurred in that matter. And as a settlement practice, I think unless there was extenuating circumstances, offering for them to pay half of the cost at this stage seems fair and reasonable to me.
I'm just trying to get a perspective on the total. I mean, it looks like it's $2,000 to $3,000 from all 6 cases, maybe, based on what you just said.
I think most cases were anywhere from like $200 to $600, but I can pull up, if you guys want me to find that information, I can get the specific amount.
Just for tomorrow, it'll be fine.
Okay,
Thank
perfect.
you.
Any other questions?
Do we have any context of what the fees were for the engagements that were delivered without the peer review?
We do not. We don't even have the, I guess, who the engagement was with. Ultimately, the only evidence is his statement to our investigator admitting to performing that attest service. So we don't have the report or who the client was in this matter, only that admission.
Anything else? I think we will wait. We'll ask the question each time and go through it, and then we'll vote on them all at the end and save some time that way. So, next case.
The next case I'll direct you to is number 15 on the report. That's case number 2025-044851. This was a referral from the Board of Licensing Contractors having to do with a review report that board had received in conjunction with a contractor applicant. Ultimately, the respondent does hold an individual active certified public accountant license, but there were violations found for performing an attest service with no firm permit and performing that attest service with no peer review. The recommendation is to offer a settlement and authorize formal charges and a settlement offer via consent order with a total penalty of $1,750 and, again, half of the investigation costs incurred in this matter.
Okay, so the question here is it's for $1,750 civil penalty. Okay, and half the cost, and that half cost to be put down for tomorrow, on tomorrow's report, so we can kind of identify what that cost is, based on the same as the other case.
Sorry, repeat that. I was looking at the report. I apologize.
Okay. So in other words, along with this case, tomorrow we'll have the cost, what that cost is on this case?
Yes,
Okay.
I can update all that during the full board meeting tomorrow.
Any questions on number 15?
All right, moving on. Number 16 on the report, that is case number 2025-045651. This was a complaint that was opened internally based on a CPE audit of a respondent, a licensee, and that was during the 2023-2024 period. In this matter, the only violation that was found was them they did fail to respond to that board's communication within 30 days. So ultimately, I'm only recommending formal charges for that one violation and a settlement offer via consent order with a $750 penalty for that violation and then half the investigation cost incurred in this matter.
Any comments or questions? All right, seeing none, number 17.
Number 17 on the report, that is case number 2025-048951. This complaint was open internally. It was based on a referral from the Board of Licensing Contractors, again, surrounding a review report that a licensee or the respondent in this matter had issued. The respondent does hold a CPA license out of state, but there was no record of a firm permit or enrollment in peer review. Ultimately, after investigating this matter, that turned out to be the case. There was no firm permit or no peer review when the respondent did issue this review report. Again, recommending a authorizing formal charges and a settlement offer via consent order with a $1,750 civil penalty and half the investigation costs incurred in this matter.
Any comments or questions on that one? Seeing none?
All right. Number 18 on the report, that is case number 2025-048631. This was another Board of Licensing Contracts referral surrounding a review report issued by this respondent. And again, the investigation and review of this matter revealed that there was lack of a firm permit and lack of peer review when the respondent did issue this report. Again, recommending a $750 civil penalty via consent order and half of the investigation costs incurred in this matter.
Any comments or questions on that case? All right.
Okay. Number 19 on the report, that is case number 2025-045661. This was a complaint, again, opened internally based on a CPE audit. Throughout review and the investigation of this matter, it was found that the respondent did fail to respond to board communications. And additional to that, it was discovered in the investigation they did not fully meet their CPE audit requirements for that period. I'm recommending that you authorize formal charges for those violations, a settlement offer of via consent order with a $2,000 civil penalty, and half of the investigation costs incurred in this matter.
Any comments or questions? All right.
Okay. Direct you to number 21 on the report. That is case number 2025-045641. This was another complaint opened internally based on a CPE audit. Again, the review and investigation of this matter revealed that there was a failure to respond violation, and again, a lack of CPE compliance here that had to do with 2 hours of the 2-hour ethics that are required during that 2-year period. I am going to recommend authorizing formal charges for the failure to respond and lack of CPE requirements in this matter, and a settlement offer via consent order with a $1,000 civil penalty, and also half of the investigation costs incurred in this matter.
I have one question about this, and maybe, I'm sorry, did I interrupt? And maybe a few of these other ones you've covered.
Sure.
And the failure to respond, what are their excuses for failing to respond?
It varies in case, did you have one case in mind?
No, I
think-
mean, I guess I didn't get my email, went to spam, you know.
Most of them have to do with that they did not appropriately update their contact information with the board, which the onus is on them there. And so a lot of times they may say that, you know, I've moved offices or I wasn't there during business hours. That's not my email address. But ultimately, board rule requires them to update that contact information with,
Right, right, 30
with the
days, yeah, I
board.
know
Yes.
that.
And
I've
sometimes
moved several
with the
times.
certified.
I've moved several times, I know.
You all have had to do that, yes, sir. And then, you know, sometimes they may claim that they did not receive a certified mailing, which may be the case, but sometimes that has to do with the same stuff. They haven't updated their contact information. They weren't there during regular business hours. And even when the post office has you know, posted to their door that they need to come pick up a certified mailing because they weren't there. Again, the onus is on them. They've gotten notified that they need to pick up a certified mailing at the post office, and they did not do it. Sometimes they don't do it timely, and that's ultimately returned to us. But that's still a violation in my opinion.
I mean, I've found certified mail delivered to me that I didn't sign for. And it's in a P.O. box, or I have a P.O. box, and, you know, it's been sitting there for weeks, and I never saw it, because I don't check that P.O. box, or whatever the situation may be, even though it's certified. No one signed for it, so.
All right. Was that my, are we going to do the present separate, or? Yes, that was 21. Yeah. Forwarded over to Lee.
Yeah, and Lee, we've got case 13, 20, and 22.
Yes, sir. 13, like some of the others, respondent was chosen for the CPE audit for the 2023-24 year or term. She did not respond to the initial email that went out that gave a June 30th deadline. As a courtesy, the department extended the deadline to July 30. She still missed the deadline. She does not dispute receiving these requests. She finally responded August 25th. And the board staff looked at the response and determined that she had completed all required CPE. But the failure to respond, again, is the issue here, and that's a violation of board rules. So the recommendation is a civil penalty of $250. And I word the costs recommendation slightly different on mine, but it's the same concept. I'm recommending costs of $65, which is essentially an hour. Number 20. Very similar case, but not the same. And that's something you'll notice. The cases might be similar, but they're never the exact same. Number 20, respondent was chosen for a CPE audit for the same tax year, 23-24. He did not respond by that deadline that was initially provided, June 30. Again, as a courtesy, the board extended the response deadline to July 30. He missed that deadline. Accordingly, the board filed the present complaint. The respondent finally provided the CPE audit response August 27th. He said, quote, "I did not receive the request for the audit documents until late July and have uploaded the CPE certificates to the internet." So board staff determined that he did complete all required CPE. Now, there's, again, like the prior case, a failure to provide a timely response. He's given an excuse that he didn't receive the initial request. But that actually goes against him because that raises a different violation, an additional violation. It was determined that this respondent failed to update the board as required under the rule with the correct contact information. So it's actually two violations in this case, and the recommendation is $250 per violation for a total of $500 in civil penalties. And again, I'm going to note this for the new members, that what the board is doing here is voting to authorize the commencement of formal proceedings. So you're authorized, if you vote to do that, then we have your blessing to go forward and file paperwork and have a full hearing, okay? But you're authorizing a second thing. You're authorizing as an alternative settlement. You're saying, if you'd like to, if the respondent is interested in settling, and that's, of course, the most efficient way to resolve these things often, then you are authorizing the specific settlement authority. So here, you would be voting to say, all right, counsel, you are authorized to settle this case if the respondent is willing, and you're authorized to accept $500 as the settlement. And of course, we're tacking on here costs of $65, so it'd actually be $565. So that's what you would be voting to do: two things: authorize commencement of a formal proceeding, and oh, by the way, if we can, let's settle it for $565. So that's the recommendation here for this case. And then number 22, this is a different case. This is essentially the failure of a respondent to provide the client's paperwork to the client upon request. So I'm not going to go through, this is a lengthy statement, and it quotes a lot of what the respondent's partner who was involved here said in written communications with his client. But I'll just kind of hit it at a high level and to say that here the client requested copies of tax returns, and the CPA said no. And so the client kind of was at a loss and filed the complaint with this board, which of course the board wants people to do. If people feel wronged, they are encouraged to file a complaint with this board. And that's what that's one of your main functions, is to handle complaints. And the CPA ordered her to withdraw the complaint. He ordered her in writing to withdraw her complaint. And then he said, I'll give you the paperwork, but only if you withdraw the complaint. And finally, a couple of weeks later, or a week later, the CPA, and again, the respondent here is the full firm, but he's one of three partners. The firm finally gave the client's paperwork to her as requested. But they said, come pick it up at the office here in our address in Tennessee. Well, they knew very well she's a resident of Florida. So then 2 days later, they put it in the mail, and that happened to be a date of a court hearing. So that they knew about, and the CPA, the respondent's partner actually traveled to the hearing to testify against the CPA. That, again, I'm trying to avoid going into the very lengthy 2-page plus summary, but I'll be glad to answer any questions you have. But the recommendation here is that the board authorize the commencement of formal proceedings for the violation of the rule that requires a CPA and a firm to provide the client's documents to the client upon request. Of course, the rule says you have a reasonable time to do it, but that's if you're going to produce the documents. He could have said, yes, I'll provide you those documents, and I've got a reasonable time to do it. But the reasonable time language is totally irrelevant here because the CPA just actually said no. Initially, response was no. So, and second, because of the way the communications occurred, which is all spelled out here, and because of this particular partner said, withdraw your complaint. I'll produce the documents if you withdraw your complaint. That kind of behavior, and then making it available in one state when you know the person lives in another state. I recommend an additional authorization of formal proceedings for acts discreditable. And then there's a third question that's briefly mentioned here about conflict of interest. There's not a recommendation of actual of a violation here, but it's if this case doesn't settle, then I think it's worth exploring. And so, just to kind of as a placeholder, the recommendation is to let me just turn to the exact wording. So the recommendation is to commence formal proceedings under 3 different rules, and authority to settle the matter via consent order with a civil penalty in the amount of $1,000. And the point there is that would constitute $500 for the denial of a request for documents and another $500 for acts discreditable. And then just a letter warning on the conflict of interest. That would have to be fleshed out in discovery if it came to that. So, again, that's in the proposed discipline section. I think we got 2 more cases in the report.
Lee, I have comments about this case.
Yes, sir.
This case bothers me a lot because in my line of work, you know, we say, call the CPA firm, get your tax returns, wife, because it's the husband's business, let's say. It's a divorce case. This happens unfortunately, this happens much more than it should. And the way that they responded to her, I think it's just completely unethical. I mean, this is pretty egregious to me. And to ask her to withdraw, you're talking about intimidation. I mean, I don't know that that's even legal. I mean, is it? I mean, I don't know. I don't think $1,000 covers that at all. I'm thinking $2,500 at least. We need to get their attention so we don't do that again. Because this case, the wife, is at very much of a disadvantage in this situation because you know, the husband maybe he owns the business. He's going to continue to be the client, obviously, because one of these partners flies down to Florida to be his expert witness, which is another possible. I think you mentioned that. That's another possible problem there. They represent both of those clients, and he's splitting off and going to go in with one of them. So I don't know. That also is concerning. I haven't been in a CPA firm in a long time, but that was always a problem. If the firm was the client, can you be an expert witness for them? I think the answer is probably you shouldn't. And I'm not sure that's even legal. This case bothers me. I think that the fine should be at least $2,500. That's my recommendation. That's my suggestion.
And for the benefit of the new members, I'll just mention a couple of things. First of all, of course, this is just an illustration of how this is merely a recommendation. I mean, what we put in this legal report is just a recommendation, and the board can handle and respond and impose discipline or not impose discipline as the board sees fit. And that goes down to the dollar amount for the civil penalty. Now, another point to raise is, I think it's 56-1-308. There's Tennessee Code 56-1-308. That's the general statute in the Tennessee Code that gives authority to boards to issue civil penalties. And there's a limit of $1,000 per violation, which, you know, in certain cases is not enough. Not a lot. I'll put it that way, not a lot. So the statute does, the law does say, okay, that's per day. So a continued violation, it can add up 1,000 per day. And here we know the dates. We see clearly that the acts discreditable that are described here occurred on at least 3 days: the initial communication, the second communication, and then the provision of those documents in Tennessee versus Florida. So that's that could be, you know, in theory, $3,000 because there's 3 violations on 3 different days, and then the refusal is a violation of a different rule, so that could be a $4,000. So then what the board does is just decide what you think is appropriate. And again, this is at the settlement stage. You're authorizing 2 things. Go ahead, counsel, you can go forward with formal proceedings and get a hearing going. And secondly, if everybody's willing, you can settle for X amount. So that's what you would be deciding today. If you do want to authorize settlement, you authorize what amount. And so I don't know how the chairman would like to, committee chairman would like to handle this in terms of motions. You can craft a motion any way you wish. And so I just leave that up to you, of course.
Can I ask a question?
Yes, sir. Who?
Right
Yeah, just
Yes,
a
sir.
quick question.
Mr. Moore.
Under the Tennessee Code, it's obviously a breach to refuse to give them their documents, correct?
Yes, sir.
would it be considered, is there any other different kind of violation for, I don't know if that's considered a bribe or not.
Oh, I don't know about that.
I'll not give you them, or I'll give you them if, because that's, or is there any separate, does the code even address that as a separate issue, or is that just kind of considered overall with refusal to give? To me, it's kind of a different action.
Well, I kind of misspoke a second ago. You said, is it a thing required by statute? It's actually a rule, and I think the rule cited here. But the rules that have been, that the board has drafted and enacted are, of course, all authorized by the act, by the Tennessee Accountancy Act. So they're all authorized by the Tennessee Code. Now, I think 62-1-111 and 113 are kind of very broad listings of violations that the board can review. They're, you know, of course, the whole Tennessee Accountancy Act is full of things that can be, quote, violated, but 111 and 113 are kind of your primary lists. It just so happened in this particular case, the violations fell under rules promulgated under the act. Does that answer your question? No, I think your specific question was on like a crime. I'd have to look back over the list. Is there, you know, if you were
Maybe
to
not,
look-
maybe just, I didn't know if there was a separate rule. Maybe I used the wrong word.
Well, 111, okay, 111. That is 62-1-111. That's one of the statutes that the board is enforcing here. I mean, that's one of the things that the board does. And it lists a number of instances of misconduct that can be disciplined. So I'd have to look it over. You're asking a question that kind of goes beyond the scope of this recommendation. So I'll only really, right here on the spot, answer it in a general way. But yeah, the Accountancy Act has lots of choices, but when we looked at it, we kind of thought that the most readily provable violations were the ones that are listed here under the rule.
So Lee, they violated board rule 002003.1.11 on September 5th. They don't supply the returns until the 17th. Okay, that's 12 days. That's $12,000. $1,000 a day. I'm not recommending 12,000, but I think 2,500 based on $1,000 per day is reasonable. It's more than reasonable. Just the fact that they were, I think this is completely unethical, what they did, and especially the way they did it. And we got documentation of it. It's not a he said, she said. You got emails for this, right?
Yes, sir.
Okay. I don't think there's any question of it. So I would like the fine increased to, or the fee increased to $2,500 based on the per day violation.
Well, I defer to the enforcement chair on how to present that for vote. Of course, it's up to y'all on how you want to handle that.
We can do $1,000 a day. I think he's proposed 500.
Well, let's see, the proposal here listed in the recommendation is $500 for the violation of the rule requiring you to give over client's papers to the client when requested. And then an additional $500 for acts discreditable. And I think what Mr. Vance is saying is that the dollar amounts that are put there he'd like to see a higher amount. But now, again, there's a $1,000 limit per violation. So if you were to say 2,500, I think it'd be best on the record to explain, you know, the dates and the amounts that are paired with each date.
And that's what I'm trying to do right now, is that maybe we do $500 a day times 10 days.
Oh, I see, okay.
And then we aggravated Rule 12 and take it to 1,000. And that comes up with a $6,000. And then we state very frankly that, you know, that there was a pattern here that was unethical.
I agree.
So
I guess we should restate that as a new motion then?
Well, it definitely will be a motion. This is still in the question and answer phase of what
Right,
the
right,
recommendation
right, right.
is. But we just need to write something down there that kind of addresses that.
You know, Mr. Bonner, what you might want to do is
Okay.
separate this case out
Okay?
and deal with, I think 9 of them didn't have quite this much discussion, so you
Right.
could have a group vote on the 9 and then have a separate vote on this, because it might require like multiple motions, depends on how people want to handle it.
So we're going to separate out number 22. I'll ask if there are any questions for case number 13 or comments. That was the first one that Mr. Lott went through, and then case number 20. Any questions or comments? All right, given that, I would like a motion to approve under the proposed disciplines to accept the recommendations and to go after formal proceedings or a settlement offer as recommended.
And Mr. Bonner, you're talking about 13 through 21, that entire list?
Yes, sir.
Cases 13 through 21 on the legal report?
Cases 13 through 21 under the proposed disciplines report, and 22 we'll address in a second. Was that clear as mud?
I got it. Thank you.
So I'll need a motion.
For number 22.
No,
Oh, for the recommendation.
for, I need a recommendation for a motion for cases 13 through 21 under the proposed discipline for approval, as recommended.
Right. It should be 13 through 24, right?
No, sir.
No, 21. We're going to pull 22 out, and then we have still got to
Right,
discuss
right.
23 and 24.
Oh, we haven't done 23 and 24 yet. I'm
Right.
sorry. Okay. Should we just do 23 and 24 and then put it all together at one time?
Now, we're going to go ahead and break it down and then discuss 22, and then we'll talk about the re-representations later.
All right. All right, let me.
Mr. Vance, 23 and 24 are a separate category. They're called
Oh, okay.
representations,
Gotcha.
which I often mispronounce as representation, and people are like, what are you representing?
Okay, so this is 13 through 21. Okay, I make a motion that we accept 13 through 21 as proposed, and that we take 22 out separately.
Okay, I have a motion on the floor. Do I have a second? Second. All right, all those in favor say aye. Aye. Opposed? All righty. Number 22. Now we're back. Mr. Vance, would you like to jump in on that one? And
Well, I think the number of days in question is 12, from September 5th, when the formal request was made for documentation, and it was denied. And they finally provided it on the 17th, although they mailed it on the 17th, so they still didn't provide it until probably several days later. But we'll just cut it off on the 17th. That's 12 days. I propose $500 per day. That's $6,000. If we're going to go on a daily basis like that.
under point 11,
Yes.
okay? And then what about point 12? Keep that at the 500 or take it up to the aggravated level of 1,000?
I was mostly concentrating on 11. Let me look at 12. Sorry. That's actually discreditable. They did both. Okay.
Any other comments from any other committee members about that one, or?
Yes, please.
Or board members?
Mr. Chairman, I'm not on the committee, but I do have a comment or two. First of all, I think a higher penalty is very appropriate, so I think we're headed in the right direction there. This is really bad practice. But secondly, Mr. Vance is correct regarding representation of opposing parties in a conflict. Both of those parties are this firm's client. And you can't testify against one or the other. And I'm almost positive that's in the AICPA Code of Ethics. It's certainly in some of our published literature regarding ethics.
I will add one thing that to make sure everyone's on the same page about the evidence. I think that was it the initial September 5th email from the respondent's partner said, oh, by the way, you're no longer a client. So I believe it was on September 5th when the CPA said, you're no longer a client, and then the hearing was September 17th.
Yeah.
So,
And I also would like to state that we're making an assumption about what the CPA reported in court. I mean, it may be as simple as, did you prepare these returns, so these are accurate returns, and so forth. And so I don't know anywhere in that legal report or in the investigation that it indicates what the person was reporting on or what side they were on.
that's the very reason that my recommendation is that we, at this point, if we were to settle, if the board were to settle this case with this respondent, and the respondent, by the way, is the firm. Of course, the partner speaks to the firm, but this is the respondent is the firm. So if the board settles with the firm, then it would merely be a letter of warning on conflict of interest. I don't know that there's enough evidence at this stage to insist on a settlement at a dollar amount for conflict of interest. However, I'm making a note here, importantly, that the issue's a live issue, and if settlement can't be achieved, then discovery will occur. And then in discovery, we can learn more about what happened at the hearing and all the communications about what you're pointing out. I think.
So I was not going to recommend a monetary penalty for that. I was taking it to exactly what you just said, to a letter of warning, because we do not know. But if in fact this person did the things that we're talking about may have happened, it was definitely a conflict of interest. But we don't know, and I think in this case a warning is appropriate, but also like the higher penalties.
So, Mr. Chairman, I have a question for you. Being out of public practice for a long time, so clearly a joint tax return was prepared for the husband and wife. Can they fire the wife like that while they're still married, based upon the tax returns they filed as joint? I'm just curious, is that even as we say, is that even a thing? My kids might say. Yeah. I don't know the answer to that.
I'm not sure of the answer to that either. Yeah. I think that they could fire her, but I don't think they can use the past tax return information against her. Or
okay. All right.
I would agree with that, Mr. Chairman, that they could, for future services, they could deny future services. I don't know if I would go so far as to say fire but technically you did. But then they would also have to, they would have to represent both parties for anything that was previous evenly and not take a side under the Code of Conduct.
I mean, are we at the point of me making a recommendation for this?
To amend the recommendation. Yes, sir.
Amend the recommendation. All right, I would like to amend the recommendation that we, based upon the dates of September 5th through the 17th, period of 12 days, we fine them $250 for violation of 11.
Our lowest fine is $500.
Well, I'm going to move to $250 per day times 12 for violating .12 also. .11 would be $3,000. .12 would be $3,000, a total of $6,000. I think that's reasonable. I don't think $12,000. I think that might be that's a little high. I think $6 is very reasonable based upon the facts that we have. So I guess I need to shorten that recommendation. $250 per day times 12 days, $3,000 for violation of 11. $250 a day times 12 days equals $3,000 for violation of 12. Total of $6,000. And a letter of warning about the potential conflict of interest if one partner were to testify as an expert witness against the wife, who was a client at the time.
And I'll update that. I'm looking at the penalty range right here on our matrix, and it is 0 to 1,000, and with our normal violation being 500. So I think that's a good choice.
I just wanted to quantify it with days, so I think $250 a day it was appropriate. Because they easily could have emailed this and should have.
Any other thoughts or questions from the committee and/or the board, since we'll probably be discussing this tomorrow?
Yeah, Chairman Bonner, I guess I'm not disputing the math, though I am not sure whether, if this ultimately is to hopefully induce a settlement, I'm not sure I would provide the mathematics to the individual, just say we're settling this for 6,000, as opposed to it's 250 times this and 250 times that, because if there's some quibbling about, oh, it's 11 days, not 12, or this or that, or, they want to get into very specific detail, then I don't know, Lee, if that puts you in now it's not 6, it's 5,500, or something to that effect. I would that personal view would be, it's 6,000, here it is, as opposed to it's this for this many days and that for that many days. I would just maybe avoid that.
Well, of course, the key here is that this is settlement. So if the respondent chooses to settle, the respondent's going to accept the dollar amount, and it will be a settlement. If this respondent refuses to settle, we'll go through discovery and have a hearing. And at the hearing, of course, the penalty could be $1,000 per violation per day, so much greater than 6,000. But and that's really where the key analysis would have to occur, to make sure it falls under the statute and falls under the case law, to make sure that each violation each day is properly supported. And that would be the evidence that we put on at the hearing.
No, I understand that. I'm only just saying, I would tell them this is a $6,000 settlement, full stop. And just give them that.
Yeah, that's a great point. Mr. Johnson just told me that the settlement letter would not even go into that. That's not the settlement proposal, and then the draft consent agreement that's presented to them for consideration doesn't even go into that. So I think, of course, the deliberations of this board are public, and this is recorded and will be available for the internet to see, but that goes nowhere, because at the end of the day, this is just a settlement. If they want to settle, they can settle.
Respectfully, I have a question, though. If we go over $1,000, and we only have 2 violations, so if we go over $2,000, don't we have to go on a per-day basis in order to get to $6,000? That was my understanding. Is it in order, we have 2 violations, $1,000 maximum each. So if we're going to do 6,000, I thought we have to quantify it on a per-day type basis.
I think it was perfectly reasonable to do that.
No, but I'm saying, that don't we have to, though?
I think you're exactly right. I mean, reason stands that if it's over 2,000, it's only 2 violations, so there's got to be more than 1 day.
Right.
And the documented correspondence shows multiple days of acts discreditable.
Right.
So.
Well, the divorce was filed on the 4th, and the paperwork.
No, well, not the divorce. The request for documents.
And I guess the denial was made on the 5th.
Correct.
Okay, all right. So it's 5th through 12, or 5th through the 17th. The 17th being the day they allegedly mailed it to Florida.
Yes, sir.
Late.
Right.
After the hearing had already occurred.
Well, on the 15th, they made them available in the wrong state, but then 2 days later, on the 17th, they put it in the mail. Yes, sir.
And I think that's pretty consistent with what we've done in the past. We've always, in this committee, talked about the penalty per day, and then the multiples. And then we reference it in our report tomorrow, and then you send out the settlement that has something as a total figure.
Yes, sir.
Okay. So I would say that we maintain that same, would be my recommendation, that we, and I agree with the fact that it's already public knowledge anyway, so.
Sure.
Would you like me to change my recommendation, or can we just leave it the way I stated it?
I would leave it the way you stated it.
Okay,
And
all
then.
right. But it's just not going to be that kind of detail going out in a letter is what we're
My-
saying.
Based on, I didn't know this till just now, but based on what the question was, and the answer is that it's never been part of it that goes out. It's
Well,
just,
sometimes the proposed or draft consent agreement will say $2,000, $1,000 for this violation, $1,000 for that violation. It didn't have to. Again, this is a settlement. At the end of the day, that's all that the board is authorizing: two things: the commencement of formal proceedings for violations, and secondly, authority to settle. And if the respondent doesn't want to settle, the respondent does not have to settle.
If they want to know how we came up with it, they can listen to this
Sure.
proceeding, or they can, certainly you can answer that question if they ask you.
Absolutely.
Okay, thank you.
Rob, did your recommendation include costs?
It did not. Costs are a big thing to me. I think I would like to add the exact same wording plus assess half the costs.
Yes, sir.
all right. So with those, you'll have to repeat them one more time and make it as a formal recommendation for number 22. Well, why don't we just have Mr. Lott read it back as far as what his understanding is what the proposed recommendation is now.
So number one, authorization to commence formal charges for violations of, get the exact numbers. Board Rules 0020-03 .12, .11, and .04. And separately, or additionally, further authority to settle via consent order. And the consent order would include a civil penalty in the amount of $6,000 plus costs to be calculated as half of costs incurred in investigation fees, which we can report tomorrow.
And is that, yes, period, okay. Is that going to include your time too?
No, sir.
No, okay, it's not
Not
at
at
this
this
point,
level.
just Duke's.
Correct.
Okay, thank you.
All right, I have that as a motion. In a second. All those in favor, say aye.
Aye.
Opposed? All right. Mr. Chairman, I've got two more cases. Do you want to take a break before we go into those? Or you want me to just,
We can roll either way.
it's up to the board.
You may need a break right this second, or we can hold.
Finish it off.
Sure. Let's do the last two.
Okay, all right. So, Ms. Johnson,
Yes, sir.
number
Direct-
23.
Direct you to the re-presentation section, number 23, that is case number 2024-046751. Earlier this year, there was an agreed summary suspension order that this board issued. Some of you may recall that. This was due to an indictment against the respondent in federal court with several allegations. Ultimately, that respondent has now pled guilty to one count of wire fraud and count 5 in that indictment of aiding and assisting the preparation of false tax returns. The new recommendation, now that that criminal case has the outcome, we know the outcome, is to authorize formal charges for violations of TCA 62.6, 111.8, which is conviction of a felony with an element of dishonesty or fraud, and TCA 62.6-111.9, performance of any fraudulent act while holding a license, and a settlement offer via consent order whereby the respondent would just agree to the full revocation of his license. All right, and that's, I think you've got the rest, Lee.
Any comments or questions? I guess in these situations, I kind of look down and think, well, gosh, they're not getting penalized or anything, but they've lost their profession. They've gone to criminal court. Heck, they may be in jail and not have the ability to pay. And so in that case, this board has in the past said, well, if they go ahead and agree to revocate their license, then we will take that instead. And usually we're very successful with that. So that's the reason you don't see a penalty or a fine associated with this one. Do I have a motion to accept it?
So moved.
Second? All right, all those in favor say aye.
Aye.
Opposed? Okay. Number 24, Mr. Lott.
So this is another case that was placed initially in litigation monitoring pending a criminal case. The allegation stated in summary fashion is that the respondent participated in a multi-million-dollar scheme to defraud financial institutions. And the board staff, the investigator were in touch with the IRS investigator for a number of months, many months. And finally, we learned that the respondent chose to plead guilty. So the respondent pled guilty in this criminal case on June 6, 2025, to a total of 16 felonies. One for conspiracy, five counts of bank fraud, 5 counts of false statement to financial institutions, 1 count of false statement in a bankruptcy, 1 count false statement under oath, and 3 counts of filing false returns. So that constitutes multiple violations of the Tennessee Accountancy Act. That would include acts discreditable, dishonesty and fraud, filing a false tax return, felony conviction. So, and the citations are all listed there in the legal report. And again, the ultimate is the penalty here is what's appropriate here. The revocation, that's what's being recommended.
Any comments or questions? Do I have a motion to approve the recommendation? Second? All those in favor say aye.
Aye.
Opposed? Mr. Chairman, that concludes the legal report for tomorrow to present to the entire board after the committee. We'll have the summaries of those and the actual cost related of investigations on that report tomorrow. We've gone through the case and complaint report. We have one more section that we need to cover called agreed citation guidelines. Obviously, our committee cannot do anything except just recommend that it be approved at the board level. But everybody got a copy of that, and the rationale is that we get a lot of regulatory boards that have defined penalties or violations, I should say, of our law in Tennessee. And the purpose is that Mr. Lott prepared a memo to to our executive director, Jen, and she said that, you know, for those that we get a citation on, there's a draft that goes through and says, can you answer yes to these 5 questions? The 5th one, in my opinion, being the most important, is this the respondent's first case with the board? So this would be first-time people. We do see some repeat people, and so those would not qualify for this. If all 5 of the questions are yes, then that gives the authority for our executive director and her staff to go through and send a letter to the respondent for either an agreed-upon settlement and or to go there for a formal hearing related to it, just like we've done today on several. Then it would also allow them to send out the agreed citation with a specific law and or board rule that has been violated. and to the respondent for acceptance. I think as a committee that we should, do I have any questions or comments about that from any of the committee members? I think it's pretty straightforward and probably will save us some time related to these because they're pretty much cut and dry for first-time offenders.
My comment is that we had 3 cases with discipline this meeting, and all 3 cases with Board of Licensing Contractor violations. I think each one of them had at least no firm permit, not in the peer review program, and maybe a third one, at least those 2. So I guess the question is, would all 3 of those have qualified for this? I would think the answer is yes. Would have saved us a lot of time. At least $6,000 of fines would have gone out to $1,000 for each of the one for not peer review and not having a firm permit. So at least $2,000 apiece. So there would have been $6,000 of fines, saved a lot of time. Wouldn't have been on the report. Am I correct? Do you think that, in your opinions, would those 3 cases have qualified under this memo?
I think they would have, as long as, and I don't have that information in front of me. I believe they were all first-time offenders.
Yeah, I think they
but
were.
2 of them were at least out of state, so they're probably definitely first time
okay.
we've heard of them.
One day, when it first came up, we had 8 of them. We had 8 one day, if I remember. And that's kind of what it was the impetus for this. So I think it's wonderful. I love it.
The other thing I would say is that if they do not agree to that citation, then you all would see it on the report at that point. And it prevents from other costs being incurred, such as investigation costs.
Assuming we approve this, which I think we should, do you plan on telling us at each board meeting how many of these cases maybe have settled in this way? I think it's a good idea. We can see if it's working.
We would definitely find some way to report it.
Okay.
Definitely.
Okay.
I haven't thought through, and may I add, if you don't mind, this memo that I prepared was that you have for this meeting was something that Ms. Binkley requested, and it's not my formal recommendation. It's just saying, oh, well, under the law, here's how it would work. That's all this is, and of course, the board might decide when you have your vote on this tomorrow, I don't know, each case is different. I don't want to go through this like it's a cookie cutter, because it's not a cookie cutter. The statutes require the board to consider various factors when imposing discipline. And so you want to make sure that we follow the statutes. So all this would be a kind of a preliminary settlement attempt. And then if it fails, it would go, just like all the other cases, through investigation and legal report, and then the vote.
Okay. Well, thank you. I think it's an excellent memo, by the way. You've done yeoman's work on this. It looks fantastic. The agreed citation, I read it all. I don't know that at this moment I would change anything in it.
You want to make that as a motion?
To accept the agreed citation order memo as written?
Yes, sir.
That is my motion.
Okay, do I have a second?
Second.
All those in favor say aye. Opposed? Okay, we'll present that tomorrow to the board. Mr. Chairman, the only thing, I didn't have a reason to bring forth the memorandum that was passed out earlier, but as a committee chair, I think it would be important to possibly consider tomorrow approving the application of that by this board, since we have not done it in the past, as the code allows, and maybe going through that. But I would leave that up to I know we don't formally have to do that because we're already allowed to do it, but I guess from my view, it would be a distinction that we have changed the ways that we're applying things at the board. Or here again, not have a vote, but just say, this is how we're going to do it coming forward, and maybe share that.
Are you speaking of the costs?
Yeah, the cost.
Okay.
Yeah, for the investigation at this level.
I'm sorry to keep adding things here, but this was brought up under new business last time. Should we bring this up, or excuse me, new business, I guess. Is this old business now? Should we what's the formal Robert's Rules of Order on that? The memo we're
Are you talk-
referring to was brought up at the last meeting under new business.
Are you talking about agreed citations or costs?
Cost.
Y'all are
Costs.
talking about-
Oh, I'm sorry, I'm conflating the two. Withdraw.
Okay.
But that's all I have from our committee, Mr. Chairman.
Thank you. Let's take a break and reconvene at 3:35. How's that? Okay. Thanks for being prompt, and we will reconvene at this point, and we are at the executive section of our agenda. And Jen, do you mind to walk us through the travel and financial results, please?
Sure. So in your meeting materials, you will see I provided a detail of board staff travel in the last quarter. I traveled to Johnson City in September for a TSCPA chapter meeting. And then Duke traveled here in July for the board meeting. So total travel costs $947.15.
While we're on that, may I commend you again for reaching out to the TSCPA members and presenting. I think it's very important for us to stay involved with that, so
Thank you. I enjoyed my visit to the Appalachian chapter. Moving on to FY '25 fiscal results. So I think I previewed this at the July board meeting. But for the year ended June 30th, 2025, the board achieved a deficit of $68,070. That is lower than what we had budgeted, but a deficit nonetheless. Our reserve balance at the end of fiscal 2025 was $1,519,174. I do not at this time have anything more current to report. Are there
Thank
any
you.
questions?
Thank
on
you.
that?
Questions?
Is that deficit the third year in a row that we've run a small deficit? Is that an issue, you think, with anyone out in the legislative arena potentially?
I do expect that we will be called to a self-sufficiency hearing again in February, similar to how we were in 2025. Each regulatory board that has not been self-sufficient for 2 years in a row is required to attend those hearings.
Okay.
So I believe our reserve is still currently in a healthy place, a healthy enough place that
Right.
I'm not recommending a fee increase at this time. I think the guidance is to have a reserve. Generally speaking, the guidance is to keep a reserve between 1 and 2.5 times your annual operating costs. And our reserve is currently in that window.
I did have the opportunity of tuning in to the, virtually, to the Sunset hearing the other day. Congratulations, you guys did a great job, and proud to hear the results of that. Couldn't help but listen to the remark made by a representative from Memphis about the deficit, and I just was wondering if there was ever any concerns that we may need to address fees in the future, but sounds like you've got it under control. Thank you.
Yes, thank you.
Brad, that's a great question. The same representative that posed the question that you referred to this was the Sunset hearing, but he also was at the Government Ops Committee hearing for our self-sufficiency hearing. I think that was in February, right, Jen? So his question for the self-sufficiency hearing was a little different in that he thought maybe we should consider refunding the $1.5 million in reserves to our licensees. So, just information for you. Okay, no questions on the finances. Jen, you have provided us some information on the state-specific ethics course. Do you mind to talk us through that?
Sure. So I am probably going to read most of this memo that's been provided, and I added some history in for our new board members about a little bit about the history of the development of the state-specific ethics course that is now required in rule to be completed. as part of CPA's renewal requirements. So in accordance with the terms of the board's memorandum of understanding between the board and the TSCPA, it is the board's responsibility to provide the TSCPA a board-approved content outline for the state-specific ethics course by December 1st of each year to assist in the development of the ethics course. An outline for the 2026 ethics course has been prepared by myself for the board's consideration and approval, and it's included in your meeting materials. In 2017, the board entered into an MOU with the TSCPA, whereby the TSCPA prepares the annual state-specific ethics CPE course that's required to be completed by CPAs with an active license as part of their renewal requirements. The purpose of the MOU was to establish guidelines and parameters for the provision of consistent and accurate ethics courses for license holders. Under the terms of the MOU, like I said, the board is required to provide a content outline so that the TSCPA can develop the course every year. Under the terms of the MOU, there is no cost or funding exchanged between the TSCPA and the board. After the course has been developed by the TSCPA and approved by the board's executive director, me, the TSCPA makes the course available for purchase to other CPE sponsors. I have included a copy of the MOU for your reference, as well as a copy of the proposed outline. My proposed additions or changes from last year's outline are highlighted in red font. Essentially, I have added an emphasis for peer review. So under section E of the outline, include the basic requirements of peer review and emphasize that firms must be enrolled in an improved peer review program within 30 days of the issuance of the firm's first attest report. I have added what I would consider to be an FAQ in section D, failure to meet CPE requirements. What happens if a licensee nears the end of their renewal period and they do not have enough CPE hours to renew an active license? And then under section G, new and emerging topics, we will have discussion of the effects of the Less is More Act of 2025 and the recently implemented 2025 peer review rule changes. So with that, I'm happy to take any questions or any feedback on the proposed outline.
Yes, I have a suggestion, or a question. Is there a place where we can highlight, like this case that we just talked about how that scenario occurred and should never occur? In other words, when someone requests their documentation, their tax return that is owed to them by the firm under regulation, can we sort of highlight what happened in this case? I mean, can we do that before it's settled even? I mean, I guess that's my question. Or even should we? Should we highlight something like that? Because obviously this was a big deal. It is to me, to the board. We voted on it, or the committee. So I just think people should. I don't know that I've heard that kind of scenario discussed during the ethics courses about what happens if you don't, number one, don't threaten someone to withdraw a complaint. And number two, when they request their tax return or documentation, you got to give it to them. So I certainly hadn't heard the first one. I thought, is there somewhere we could put that?
Rob, that's really good. But I think that would qualify under F as in Frank on the outline rules of professional conduct. Then, as you know, speakers or people who present the ethics courses pick and choose some cases. I don't know. We could ask Kara to try to include that specific case in the presentation.
So I will say the case studies that are included in the course are part of the course that is developed by the TSCPA and then shared with other CP providers. So the case studies are mostly cases that come directly from legal reports that have been presented to the board in recent history. We can certainly, once we get past this board meeting and get into the process with the TSCPA of developing the course, we can ensure that that case is used as an example. All of those cases that go into the ethics course remain anonymous, but they are usually pulled directly from the legal report as examples.
Right. But I guess, do they need to be adjudicated at that point completely before it's brought up? Oh, they do? Okay, I see a yes. Okay.
I would, yeah, it would be better if they're closed first. I wouldn't want a case reported in that's still open and legal, yeah.
Jen, I was going to say, well, there's probably a couple spots where what I'm about to say could go, but we spent, over the last year or so, we've spent a lot of time on this matrix that we just referenced, the disciplinary matrix, and whether or not that's under F or that's under E or that's somewhere else. D, I guess, in part, could go there too. But I do think it would be helpful to have a more maybe explicit part of the course that talks, or it could go in G. Again, I don't know. It could go, as I said, multiple spots, likely.
Hey, may I speak to that, Mr. Buchanan?
Yeah?
Sorry to interrupt you. One small point is that the matrix is essentially the board's instruction to the staff
Yeah.
how to prepare the legal report.
Right. I guess, Lee, what I'm saying is just maybe a further emphasis on the fact that the board has, I would say we have had a change in posture the last 12 months around instructing those of you who support us to be, I don't know if aggressive is the right word, but I use it nonetheless, about recovering, like, where are the cases, the kind of cases that we have, licensing board, et cetera, CPE, but also about the fact that we're being maybe a bit more aggressive in terms of how we've interpreted what we have under statute, and will likely be seeking higher levels of fees, penalties, whatever the right legalese is, than maybe what has historically been the case. Again, I think that's obviously a matter of public record, though I realize no one, these are probably, there's very few uptake who listen to these meetings, but again, I think getting it out there for all the CPAs in the state to have a venue where we know that they're at least exposed to that would be useful.
I agree with Mr. Buchanan's comments. I know he made them at our last meeting about the revised disciplinary matrix, maybe making it public or to the public. Could we incorporate something into the materials, maybe it's an appendix, to say that the board, there's a number of things that violations, I'm just thinking, what if you were to take the matrix part itself and take the first two columns, which are the statute or rule and the violation of the brief description, don't even put the dollars out there. If people could see all the type things that you can be penalized for, or that are violations of our act in one spot, it might trigger a thought, oh, I've messed up on that, or I haven't responded to something, or I've moved and I haven't notified them, or may just be a way to generically, without guidelines and dollar penalty suggestions, say, these are the potential violations in Tennessee.
Okay, that's a great question. We just so happen to be kind of working on that actually with the matrix. Some policies, or I don't know if I'm going to use the right phrase, standard operating procedures are required by law to be made available to the public, and there's a section of the state's website that collects those and makes those available. And so I'm working with the chiefs on exactly what has to be made available and how. And so that's an ongoing project, and I don't even know that you would cut off a portion of it. I think the whole thing, if it's required to be put on the internet, we're going to put it on. And I do think it would be helpful. And I'm very sorry to interrupt you, Mr. Buchanan. My only point was that, just to make sure we're on the same page, that matrix is instruction to the staff. It's not it's not a formal announcement to the public. It's instruction to the staff on how to prepare the legal report. And then, of course, when the board votes on the legal report, you address each case on its own merits. So I apologize.
No apology necessary. I mean, that's a sort of slightly tangential point to the one I was making, but I agree. I made that comment in the past. Like, if we're gonna hold ourselves in this board, I think one of the one of the benefits of having such long members of the board is we try to ensure where it makes sense that we follow precedent, so it doesn't appear that we're being capricious in one case versus lenient in another. I have no personal objection, though, to that being made available on our website if that's appropriate, so that we're not hiding behind it. And again, we're recognizing it's just guidelines, but nonetheless, if these are the guidelines that we're going to be using, let's let the public know these are the guidelines we're going to be using.
Yes, sir.
Can I make a comment on that? In the TSCPA ethics, under directly to what you were referring to, there is, under new and emerging topics, a section that talks about the complaint, I'm looking at it, the complaint process and the results that could happen that may include closing a complaint, letter of warning, consent orders, civil penalties, so that could possibly be expanded. But it is under new and emerging topics where they do talk about what happens in the case of violations. So that's definitely an area where we can lean in.
So, if you look at the outline under item H, complaint process, there are 5 questions, basically. Could we add an item F, as in Frank, potential disciplinary action, and then include just the 2 columns that Mr. Griesbach referred to without stating the penalty amounts for this upcoming CPE year?
I'm sorry, I would just have to look to that. I don't know if I can't give you the right answer here. I'd have to study it to make sure. But I have
Well,
to say.
I'm not sure it's the disciplinary matrix
Yeah.
as much as, I remember one time we had a call about something, you said that these are sort of the potential violations of the law.
Oh, yes, sir.
Or some of the disciplinary actions, and forgetting disciplinary actions, if we just sort of had a laundry list maybe of these are the violations, these potential violations in the law, they're present in the law. You have to report this, and you can't withhold a tax return, and, all the various potential violations. It might just trigger something in someone's mind.
Oh, I see.
As part of the course.
Yes, sir.
Yeah.
I see. Okay.
Really, totally different from the disciplinary matrix, or
I
not
got
as
you.
a part of, in context of it.
I think that sounds like a great idea. I just didn't want to kind of give like a legal answer, but it sounds like an excellent idea.
One last comment. What if we included something in that same part, or request, since the range of costs will now be greater, maybe we can present that, because perhaps some members who attended those type trainings may think, hey, the max is 1,000, we can pay that, we don't really, well, I shouldn't say they don't care about it, but it doesn't really get the point across as a deterrent. So maybe also mentioning some of those ranges where applicable could be a deterrent. Or a request, I don't know.
To clarify, though, I don't think we've really changed anything on the disciplinary matrix. We talked today some about the potential number of days that a violation occurred, and that gives the board flexibility to add additional penalties. The only thing that we've really changed in practice recently is the addition of costs to the cases.
That could be a deterrent as well. It's costly to litigate.
But I do think there's a
But-
point of emphasis there that we've made around days, maybe historically, that we haven't made as much. So $1,000, yes, agreed. $1,000 may not be, may not sound that bad, but if you say it's $1,000 for every day that you do something, and the board has been, again, I'm back to my posturing point, I think we have been a bit more thoughtful about how do you apply that day count concept. That might get people's attention.
I have 2 thoughts on this. So one, I think for the purposes, I'm taking all of your feedback into consideration for the development of the course, which will happen in January, February. I think for the purposes of considering an outline, I have noted to add under H, complaint process, to add another bullet point, F, potential disciplinary action, which would be where we would expand on that. And actually, I think that was both of my thoughts. I think I said I had two thoughts. But I think for the purposes of fleshing out what the actual course would look like, I will take this all of these points into consideration when working with the TSCPA to get it documented. But for the purposes of just the outline, I have noted that addition, if that helps.
Anything else? Comments? Jen, do we need to vote to present this to the board tomorrow, or is this for information only? Or
So this outline, per the terms of the MOU, this outline does need to be a board-approved outline.
okay,
So I think that there needs to be a motion to take to the board.
okay. So and I'm personally good, so I'm speaking as a committee member, with the outline as presented with the addition of item HF, right? So executive committee members, any comments, motion to approve?
I make a motion to approve.
Motion to approve?
Second.
Second. All in favor, aye?
Aye.
Great, motion approved. Okay, Karen, at this point, do we have anyone signed up for public comment? No, sir. No? Okay. The TSCPA representatives typically are at our committee meetings and board meetings, but they're at a conference, I think, is that an AICPA conference? I think, for the council meeting for the next few days, so they're not here today and will not be presenting for us tomorrow. So we will miss them. Okay, at this point, I would entertain a motion to adjourn.
So moved.
So moved. Second? All in favor, aye?
Aye.
Aye, thank you. Welcome again, new board members. Thanks, Amelia.